Members of the jury, you now have all the evidence. I will give you instructions that you will follow in deciding this case. You have two main duties as jurors. The first is to decide from the evidence what the facts are. Deciding what the facts are is your job, not mine. The second duty is to take the law I give you in the instructions, apply it to the facts, and decide if the prosecution has proved the defendant guilty beyond a reasonable doubt. You are bound by your oath to follow the instructions that I give you, even if you personally disagree with them. This includes the instructions I gave you before the trial, any instructions I may have given you during the trial, and these instructions. All the instructions are important, and you should consider them as a whole. The order in which the instructions are given does not mean that some instructions are more important than others. Whether any particular instruction applies may depend on what you decide are the true facts of the case. If an instruction applies only to facts or circumstances you find do not exist, you may disregard that instruction. Perform your duties fairly. Do not let any bias, sympathy, or prejudice that you may feel toward one side or the other influence your decision in any way. During the trial, I have made certain rulings. I have made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. As the judge, I am neutral. If I have said or done anything that makes you think I favor one side or the other, that was not my intention. Do not interpret anything I have done as indicating that I have any particular view of the evidence or the decision you should reach. You must base your decision only on the evidence that you saw and heard here in court. Evidence includes what the witness said while they were testifying under oath and any exhibits admitted into evidence. Nothing else is evidence. The lawyer's statements and arguments are not evidence. Their objections are not evidence. My legal rulings and comments, if any, are not evidence. In reaching a verdict, consider all the evidence I have defined as I have defined it here, and nothing else. You may also draw all reasonable inferences from that evidence. Facts may be proved by direct or circumstantial evidence. The law does not treat one type of evidence as better than the other. Direct evidence can prove a fact by itself. It usually comes from a witness who perceived firsthand the fact in question. For example, if a witness testified he looked outside and saw it was raining, that would be direct evidence that it had rained. Circumstantial evidence is indirect evidence. It usually comes from a witness who perceived a set of related events, but not the fact in question. However, based on that testimony, someone could conclude that the fact in question had occurred. For example, if a witness testified that she looked outside and saw that the ground was wet and people were closing their umbrellas, that would be circumstantial evidence that it had rained. Before you can find the defendant guilty of any charge, there must be enough evidence, direct, circumstantial, or some of both, to convince you of the defendant's guilt beyond a reasonable doubt. It is up to you to decide. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you are convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one or one witness against many. In deciding whether a witness testified truthfully, remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same events differently. A person accused of a crime may choose whether or not to testify. In this case, the defendant chose not to testify. Do not hold that choice against the defendant. Do not try to guess why the defendant chose not to testify. Do not consider it in your deliberations. Decide the case only on the basis of the evidence. The defendant does not have to prove that he or she is not guilty. The prosecution must prove the defendant's guilt beyond a reasonable doubt. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crimes charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If the evidence leaves you firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. On the other hand, if there is a real possibility that he or she is not guilty, you must give the defendant the benefit of the doubt and return a verdict of not guilty. The law requires that the prosecutor prove beyond a reasonable doubt that the defendant acted with a particular mental state. Ordinarily, there is no way that a defendant's mental state can be proved directly, because no one can tell what another person is thinking. A defendant's mental state can be proved indirectly from the surrounding facts and circumstances. This includes things like what the defendant said, what the defendant did, and any other evidence that shows what was in the defendant's mind. A defendant's mental state is not the same as motive. Motive is why a person does something. Motive is not an element of the crimes charged in this case. As a result, the prosecutor does not have to prove why the defendant acted or failed to act. However, a motive or lack of motive may help you determine if the defendant did what he or she is charged with doing. It may also help you determine what his or her mental state was at the time. In making your decision, do not consider what punishment could result from a verdict of guilty. Your duty is to decide if the defendant is guilty beyond a reasonable doubt. Punishment is not relevant to whether the defendant is guilty or not guilty. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach a unanimous agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all of the evidence. Try to reach unanimous agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, Do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own. Because this is a criminal case, every single juror must agree with the verdict before the defendant can be found guilty or not guilty. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. Rather, the verdict must reflect your individual, careful, and conscientious judgment as to whether the evidence presented by the prosecutor proved each charge beyond a reasonable doubt. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as a jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinion should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict forms on behalf of the entire jury. For each offense, the verdict form will have 2 blanks, one for guilty and the other for not guilty. The foreperson will fill in the appropriate blank to reflect the jury's unanimous decision in filling out the form. The foreperson needs to make sure that only one blank is marked for each charge. A person cannot be found guilty of a criminal offense unless the person's conduct is prohibited by law and, at the time the conduct occurred, the defendant demonstrated a particular mental state specified by law. Conduct can mean both an act or the failure to act when the law requires such a person to act. An act is a voluntary movement of the body, and it can include speech. As to the mental state requirement, the prosecution must prove that at the time the defendant acted or failed to act, he or she did so with a particular mental state. For each offense, the law defines what kind of mental state the defendant had to have, if any. For some crimes, the defendant must have acted intentionally or knowingly. For other crimes, it is enough that the defendant acted recklessly, with criminal negligence, or with some other specified mental state. Later, I will instruct you on the specific conduct and mental state that the prosecution must prove before the defendant can be found guilty of the crimes charged.